welcome to MCLE This Week. I am your host, program attorney Bruce Richard. For this month's podcast, our guests are Superior Court Judges Cannone and Ham and Beverly Cannone. Judge Ham has been Associate Justice of the Superior Court since 2021. Before her appointment to the Superior Court, Judge Ham was appointed to the Boston Municipal Court in 2019. And prior to getting on the bench, she was an assistant district attorney in the homicide unit at the Suffolk County District Attorney's Office. And Judge Cannone is an Associate Justice of the Massachusetts Superior Court. Previously, she was an Associate Justice of the Massachusetts District Court. And previous to that, Judge Cannone was a public defender with the Committee for Public Counsel Services for nearly 25 years and was a member of their murder team. Judge Cannone has been a teaching team member at Harvard Law School's Trial Advocacy Workshop for 20 years and has chaired MCLE's Trial Advocacy Workshop for the last 4. Through her career, Judge Cannone has been a frequent lecturer and faculty member at CPCS, MCLE, and the Social Law Library, training seminars, and we are thrilled to have both of you here today. So rather than do an entire podcast where we talk about the 5 things attorneys do in your courtrooms that you can't stand, we're going to put a positive spin on things. I want to talk about the 5 things attorneys do in your courtrooms that you appreciate. Judge Ham, do you want to get us started?
Sure. We have a long 5 list and we are happy to talk about it. But before that, I have to start with this. I have to fangirl a little bit. The fact that I am doing a podcast with Judge Cannone, it is truly my pleasure and honor. As a young prosecutor, Judge Cannone was a legend of a homicide public defender. And then she became a district court judge. And when I was a Wareham supervisor, I stood before her when she was a district court judge. And then I think I appeared once before her when she was in Superior Court judge. And the fact that we're colleagues and friends and we're on a podcast together, I am totally fangirling you. So the fact that we're here together, I'm so honored. So
you have to let me talk just now. And Judge Ham was an extraordinary lawyer, and I swear she's on her way to being an even better judge. She's really gone out of her way to do everything she can to learn civil. I call upon her to do all of my programs, and she always says yes. And the future of the trial court is in really good hands. So
I really can't believe I'm doing things with Judge Cannone, but she is such a legend. Anyway, okay, I'm gonna stop fangirling. The first thing I love when lawyers do this in courtroom is I love it when lawyers use or maximize their interpersonal or emotional IQ. I think we don't talk about this as much, and certainly in law school and law professors do not teach us how to use our emotional IQ. What does that look like? Sometimes it's simple things like talking to your opposing counsel before your case is called. There's nothing I hate more when I get on the bench and say, have you both spoken to each other before the case is called? And they look at me blankly. I think that you should speak to each other before the case is called about discovery, about trying to resolve the case. And sometimes you might say, well, the opposing counsel is completely unreasonable. I understand that. I've been there before. But even attempting, showing the attempt or using your charm to try to talk to your opposing counsel. I think also another way to use your emotional IQ is reading the room and reading how the jurors are perceiving or receiving you, how you're repeating things over and over again, or how the judge is perceiving and reacting. I think that is an emotional IQ that you should have. And when lawyers have it, I love it. Judge Cannone, do you have something to say about that?
So I'm going to sort of dovetail on that, Judge Ham, with the idea that I really like it when lawyers show each other respect. Civility is something that's lacking often in the courthouse, and I really enjoy it when lawyers treat each other well, say positive things about each other, extend deadlines, common courtesies to people, to opposing counsel. I think all judges love to see that. And it goes a long way with helping the reputation of the lawyer. So I think that all goes with reading the room and your emotional IQ. And also the same sort of dovetailing on this is when it's always nice when the lawyers don't make personal attacks. They never make it personal. It should always be about the case, and real professionals do that. The lawyers that we like to see time and time again, right, Judge Hammett, the lawyers who it's just, advocating for their client, advocate as strongly as you want. That's what we like to see, but not personal attacks. And sort of in the same vein, it's really important, and we really enjoy it when we see how well you treat the staff. And believe me, we hear it when you don't. It's great when court officers come in and talk about how, pleasant the lawyer was, or was in agreement about maybe not necessarily taking the handcuffs off just yet because the guy's a problem, or, things like that we hear when there's cooperation. Because again, everybody knows there are no secrets in the courthouse. So that's it for me, Judge Ham, on that.
We both have our number ones. I think we've kind of talked about that. It's very similar. My number two is simple, but sometimes hard to do, which is tell the truth. And you might think, we're all lawyers, we're all officers of the courts, we tell the truth. And I think it's so easy to do and obvious, but sometimes so difficult when it makes you look bad. And I think as a lawyer myself before, I wanted to look good and wanted to impress Judge Cannone when I was in front of her. And sometimes as a busy lawyer, I forgot to do something or I missed a deadline. And I would have to admit that I forgot to do something. And I in civil case, I just recently had that. And I would be afraid to look lazy. And I would just have to admit that. Or sometimes I just didn't know something. I didn't know the case, or I didn't know the case law. And it's embarrassing, but rather than making up something, I think it brings me more credibility to say I don't know. And believe me, it's really hard to do, especially if your partner's watching or someone, a supervisor is watching. I understand. And I think that it's easier to do if you have a longer or a long reputation, you have some rapport with your judge. I understand that it's easier to do, but you build a reputation, a rapport by doing this. And I think that I'm not saying, I guess, tell the truth, because I would hope that everyone's doing it. I guess maybe rephrasing it as be transparent. I'm not saying tell us your strategy as a lawyer, but be transparent. And I hope and I think that judges and opposing counsels will be human and understand as well. Judge Cannone, did you have a comment about that?
My only comment about that is what I say at various trainings that I do, and what I always said at trainings I did at CPCS is, your reputation is everything. And the one sure way to keep a great reputation is to just never lie, not once. Don't stretch the truth. And if you don't lie, you never have to worry about your reputation. Conversely, if you lie once, your reputation is shot. That's that on that, Judge Ham.
Yeah, I remember, I'll give you an example. I remember I'd be very prepared, and then inevitably Judge Locke would ask me a question about a homicide case, some minute detail that I didn't know. And I would always get so frustrated because I know everything except something he'd asked me. And I think the way I've handled it was, I think one time I said, like, as much as I've prepared, there always seems to be something that you're asking, Your Honor, that I seem to not know. So I'm sorry, but I'll get that answer for you. And of course, I did that because I've been in front of him a lot and I was able to build that rapport. And obviously, your answer all the time can't be, I don't know. You have to be, but I think that being transparent and sometimes saying, I don't know, is the right way to go. I guess that goes into my number 3, so that you don't say, I don't know all the time. My number 3 is be prepared. And I'm speaking more to younger lawyers because I think I have an affinity or more, I guess, to young lawyers. I still feel like I'm a young lawyer, even though I'm a judge. I think that if you lack experience or knowledge, being prepared is how you combat that. And being prepared and knowing as much as you can is how you combat that. I actually ran this by to an intern, this list, and she actually asked me, what does it mean to be prepared? Like, how many hours should I spend on something? And I thought that was a valid question. And so for a civil case, for a summary judgment, how much time should I prepare on this? If you wrote the brief, you probably are pretty prepared. But if you didn't write the brief and you're trying to, prepare it, or, so it depends on the criminal and civil. If you're preparing like so much, I think it depends. I'll give you an example. When I was in district court, and I just keep going back to district court, there was a law firm attorney who we borrow for 6 months. And that's like a loan. And this loan prosecutor had like pretrial cases, and she would get 20 cases. And it's like 1-page cases, OUIs, trespassing. And she would make copies and take them home and study them for 10 hours. That's over preparing. I thought that's not, this job is not for you, maybe. That I don't mean be prepared that way. Okay. I don't mean like don't sleep. I think know your case well, know the case law well, that it pertains to the case, and be prepared to what the judge might ask you. I think that's what I mean by be prepared. I don't mean like spend all your waking hour preparing for it. I think I'm not saying this because an intern asked me, what does that mean to be prepared? Does that make sense, Judge Cannone?
Yes, yes, because people do sort of want concrete times, and I think that's an impossible question to answer. But on the be prepared part, like you were saying before, Judge Hammond, I'm not sure you said it this time, but about how you were telling me the other day that if you're so prepared, you can make up for little deficiencies. Like if you know your case better than anybody in the courtroom, then if you don't know the law that Judge Law questioned to you, you're still in good shape. Right. And I think that's, that was part of what you said when you said this was your number 3, and it's my number 3 as well. But on a different angle, I agree with everything that Judge Ham said. And my only little dovetailing on this is that regarding continuances, if you practice in Superior Court and you're watching this, there's a push to, way back it started the firm and fair trial dates from a long time ago, but we're encouraged to not grant continuances. And Judge Ham and I were both trial lawyers. We know that there are times lawyers need continuances, and I think we pretty freely grant them when they're appropriate. But when we grant them, we really do appreciate you being ready on the next date. If we give you time, we expect that you'd be ready on time. And one of the things I wanted to point out is that, sometimes you don't think about it. I know, especially in busy district courts, the lawyers will say, well, we just need some more time to talk about this. Why don't we just get another date? And without really thinking completely about the consequences. And for an example, years ago, we put together for the trial court a program, probably 8 years ago, for judges for the trial court on poverty. And one of the things that was mentioned is, we lose sight as judges of the emotional toll some of these cases, and always having it hanging over your head and having to come into court and have nothing happen. It takes a toll on everybody, and it especially takes a toll on poor people who have to figure out how to get to court. There was an example of a mother going to juvenile court for her young son, and having to take her baby in a baby carriage and walking from like Charlestown to BMC Central to get there to just have the case continued, to have to go all the way back. And there was a letter from Roca talking about, the kid having to take a bus, or the defendant having to take a bus to court that goes down Blue Hill Avenue and past 18 different gang streets to get to court, fearing that when he gets to court, there'll be a phone call made and somebody's going to shoot him. Like, those things are real concerns to people that I think lawyers and judges sometimes tend to not consider. So make sure you're prepared. As Judge Ham says, there's always valid reasons for continuances, but lack of preparation, I guess, really shouldn't be one of them. Does that make sense, Judge Ham?
Makes sense. It's a different twist of a different reason for being prepared that we generally, I think, lawyers don't think about as much. I think there's a different twist and different perspective on it.
Advance your practice with the MCLE Online Pass. For one monthly subscription fee, you can access everything MCLE has online: live and on-demand webcasts, ebooks, forms, checklists, and more. Start your free trial today at mcle.org/onlinepass.
I'm going to move on to my fourth one is I've been seeing I've been sitting in civil, and I want a lot of younger lawyers and I've been encouraging younger lawyers to come and argue. And I've seen a lot of younger lawyers, and maybe I'm going to reverting to don't do this. Maybe I'll try to put it in a positive voice. When trying to find your own voice or trying to start arguing or presenting your case, and when you're trying to find your own voice, when you're starting out in your career, when you don't really know how to address things or finding your own voice, revert to being more formal. What I mean by is, I think younger or less experienced lawyers think that being more informal or casual makes them seem more confident. There's a lot of okays, sure, or I've gotten a lot of, you know what I mean, Judge? Or I get a lot of judge, not your honor. And maybe it's just me because I have good genes and I look young. I don't know. Because they know I'm a newer judge. I don't know if Judge Cannone gets that, but I get a lot of judge instead of.
Oh, you calling me old, Judge Ham?
I don't know, but I would never call Judge Cannone. I said, Your Honor. I never said okay. I don't. So maybe it's a different generation, but when you're trying to try things out, revert to more formal and start out more formal. And as you're getting more comfortable, try things out. And don't be funny. Try to crack a joke in the beginning when you're new. You don't know how that's gonna land. And do it maybe later. I don't know if you know Attorney Kelly Porges. You can't be a Kelly Porges in the beginning. Kelly, I love you if you're listening.
Kelly is a phenomenal lawyer.
She's hilarious, but I don't know if she was like that from the beginning, but you can't be as funny and kind of who she is, which is, sometimes very dry sense of humor until you build rapport and reputation. So I think be more formal. Please be more formal. And maybe it's just me. I don't know, Judge Cannone, do you get that informality in your court?
Yes. I think a lot of it's post-COVID, but I do also want to say that I don't have a problem with the term judge. Now, Judge Ham, you might know this, that I grew up in a household where my father was a lawyer who hated judges. And he would say things to me like, he's not my honor, and it's just like a flat judge. But I don't have a problem with that. But I know I did a program years ago, and one of the judges of the Superior Court who was also a longtime trial judge, trial lawyer, said that he was, did not like the term judge. And one of the participants said, I use judge like I use the term, like I use it as a place saver.
It's not judge that I have a problem with. If they say Judge Hom, whatever, it's judge. There's a different tone.
It's the delivery.
In the transcript, it might look same. It's a different delivery.
Yeah. And I do think there's people are a lot more casual post-COVID. I really do. And I think, it's sad. Lawyers aren't in court as much as they used to be back when we were trying cases, Judge Hom. And, sort of on this note with the formality, I think the best way to get back the, find your voice is to go to court, watch your colleagues. We don't see that anymore. And it's a shame because people don't really know how to be in court as much. And remember on Zoom, you'd have the, associate standing there in front of the Zoom screen, but you knew the partner was like at arm's length on the other side of the camera, and she was probably terrified. Yet if she had been standing in a courtroom with the lawyers and the judge, I think she'd be able to find her voice a little bit quicker or a little bit easier. But I think if you can go to court, you can see what works well for people and you can see what doesn't work. And Judge Hom, you were sort of talking about that. You have to do what's best for you, and it might take time to find it, right? I don't know.
And my last one, I'm going to try to put it in a positive term, Bruce. I love it when people don't use their cell phones. I don't mind when you use your cell phone before your case is called. But when your case is called, maybe put away your cell phone while you're even arguing your case. And they're arguing, you argue your case, okay, you don't have your cell phone on you, you sit down, and your opposing counsel is arguing their case, and you're sitting down and looking at your phone, and I'm baffled. I see it a lot, criminal and civil. And it just gives me a perception that you don't care about your case. And it may be that you might be checking something really important. I don't know how important it is because it looks like you're texting or looking up something. And if you're actually looking up something that's really important, you could tell me I'm waiting for something that's really important, medical. I don't think that's what it is. So that's my last one. That's really a pet peeve.
Can I ask you, Judge Hom? I see lawyers using their cell phones more in Superior Court than I ever did in district. Is it the same with you, or what are your thoughts?
Same. Pretty same.
Okay.
Judge Cannone, what you went through, I think 2 out of your 5. What is your third?
So my third would be flipping it the way you did, Judge Hom. It's always great when lawyers file updated memorandum and not just boilerplate. And I hate the term boilerplate, but it's particularly important, I think, in criminal cases. There may be a reason that I think this case should be suppressed, but it's not based on Wong's son. Like there need to be updated cases because especially like in digital evidence. And digital evidence is changing so quickly. We get decisions from the appellate courts all the time, and it's really important that you need to be updated. You need to be current. So I do understand templates have their place, but I've called lawyers over and said, you're better than this. I'm going to give you a couple of weeks to file a new memo. And, and they do, and then it helps your client more. So Judge Hom, what do you think about that?
Ditto, no other comment. Well
Okay.
said.
And my other sort of minor points are to give the judge some credit, like expect that he or she has read your paperwork beforehand. And, don't just stand up in court and read from your memo. I'd like to hear your argument. And, it's great when lawyers look at me and just argue what it is they want me to understand about something, like your take, as opposed to just, reading page 3, page 4, page 5. We don't need that. And it's not that it's a waste of time. That's not why, but I don't think it's the best advocacy for your client either. I don't know. It might just be bugging me. Does that bug you, Judge Hom?
Yeah, especially civil. I think when I come out, especially because, and maybe this is my own feeling of inadequacy because I come from criminal background, I over prepare. Be prepared. That's on my list. I over prepare with civil. So when I come out and say, I've read your brief, I read the whole file. I read some case law. I didn't read all of it, but I read some case law that's relevant. I'm not lying to you. So, and then they just keep going over and over again. So then I feel as though I have to kind of stop and recite the facts back to you to kind of prove to you that I do know. And that goes back and forth kind of. So it kind of wastes time. So I guess also give us some credit, but also when we say we did read it, believe us. Because I think sometimes maybe we don't have all the time to read as thoroughly as we can. So maybe sometimes not all of us will admit that. But especially if we say we read it. I think that's a cue that we did read it. And especially if we ask questions, I think that's a good sign. I think that, and like appellate court SJC, like they start asking you questions, that's a good sign. That means we kind of are interested in your points and we give us some credit with that.
And I guess my last one, Judge Hom, you talked about, when you read the room, watch the jury and don't be repetitive. And sort of what I have on that is that be cautious of the jury's time. It really is first and foremost a concern of the judge. And, we hear from the jurors things like, yeah, that lawyer didn't need to repeat it over and over and over again. But also, we're concerned if I understand completely, there are often last minute things that come in during the course of the trial. I was the same way when I was trying cases. Things come up, they need to be addressed. Let the clerk know as soon as possible because the clerk will then alert the judge. So if I find out at 8:30 that there's an issue with the lawyers, I can say to the court officer, get coffee and we'll let them sit for a bit. I need to get out there and do this and try and get out there early. If nobody approaches the clerk and nobody knows anything and we go out and I say bring the jury in, the lawyers say no, we need to see you, that's problematic for a lot of reasons. I think Judge Hom and I anyway, and a lot of judges get there early, especially on trial, which is another point. It's amazing to me how many times I walk into the courtroom 10 minutes before trial and there's nobody there. That never used to happen. The lawyers would be there at the crack of the doors opening in the morning and prepared. But we're there early. We're waiting to get out there to try the case. If you have something, the sooner we get it, the better off we are. And there are lawyers who will do that. They'll text the clerk at night or they'll leave a voicemail saying, I've got something for the judge that we need to address beforehand. That's great. We'll give you all the time we need as long as we know and we don't make the jurors just sit there because they're not happy when they come back out an hour and a half later. It's an hour and a half they could have had at home. We all know that we wouldn't want that either. So that's it for me, Judge Hom. Do you agree with that or do you have any points on that?
I see that criminal lawyers do that better. Civil lawyers, I think that it's a tactic to spring it on each other and think that it's a best tactic to spring it on each other and argue it at sidebar and think that I caught them off guard and the opposing side won't know how to defend the case. And we're at sidebar and then they're whispering, arguing and saying some case law. And then I'm supposed to make this decision. Frankly, if you want me to get the law right, it's better to do it in a motion in limine or in the morning because I'm going to be able to look up the case law and get it right. If you think that the law is on your side, because at sidebar, I'm not going to be able to look that up. So I think in civil cases, they do that more, I think, because I think they think it's more of a tactic. And I don't think it works. So I totally agree with that, to do it in advance, to not waste jurors' time, and also for us to get it the right decisions. Right?
Absolutely. So this was fun, Bruce. Are we done, Judge Ham?
Are we done? Can I keep fangirling on Judge Cannone then?
Well, I think we'll save the rest of the fangirling for after the podcast. I want to thank both of you for coming on. This has been invaluable for me, and I'm confident for all of our listeners. So we really appreciate it. Thank you both so much. I look forward to seeing you at the next programs that we're set up for. So thank you
All
both so
right.
much.
Thank
Bruce,
you.
thank you.
Thank you. I want to thank Judge Ham and Judge Cannone for joining us today. If you enjoyed hearing from them, don't miss our upcoming program, Superior Court Judicial Colloquy 2025, on October 21st. They'll be joined by Judges Kirsten Buxton, Christopher Barry Smith, and Chief Justice Michael Ricciuti for a wide-ranging discussion of key issues before the Superior Court.
The MCLE This Week podcast is a production of Massachusetts Continuing Legal Education in Boston, Massachusetts. For sponsorship opportunities, email us at podcast@mcle.org.